None of this is really rocket science. It's really just about reading the statute. I don't want to make lawyers out of all of you, but the statute is somewhat complex. It's in many ways very difficult to follow. I'm guessing all of you have at least one volunteer lawyer in the chamber, and you can impose on them to help you with all of this. I'm trying to remember what the title of this is and what I was supposed to actually do.
Bylaws, policy.
Why do we need them? Oh, why do I need them, and when do they need to be changed? Well, you need them because by law you have to have them. That's why you need them. So anyway, let's just get started. Couple of things. Having served on a ton of nonprofit boards over many years, one of the things I have run into routinely is that some nonprofit execs confuse policies with bylaws. And every time the board decides, well, I think we should paint this green, oh, we need to amend the bylaws. No, you don't. There's a difference between policies and bylaws. So I think you ought to keep that in mind. The definition of bylaws is a rule made by a company or association to control the actions of its members, and I put in parentheses and define duties and authority of directors and officers. So big picture here, there's very little in the statute about directors and officers. So for bylaw purposes, it's fairly wide open. And I didn't put a lot of stuff in here, in fact very little, about directors and officers. You have a pretty open canvas for how you want to set up your directors, how many you want, how they're appointed, and so on and so forth. So I didn't spend a lot of time on that. Obviously, the directors are elected by the members, although you can have appointed directors. There are a variety of things that you can do. But I'm going to just assume that you have a pretty routine setup in your chamber where the directors are elected. Now, I shouldn't say that because in our chamber we have certain elected officials who are automatically members of the chamber. And again, you can do all of that. There's nothing in the statute that's going to prohibit you or regulate that. One of the things that I see pretty routinely in nonprofits is, especially in chambers of commerce, is a lot of language in which you don't really explain the difference between a person as a member and an entity as a member. So all of you have individuals who are members. They may be in business, but they're sole proprietors. It's just them, or it's just that person and his spouse. And then again, you all have entities. You have LLCs and corporations. And the question is, how do you in your bylaws handle that issue? So, because the company typically is the member, right? It's the business that's the member. All right, so if you have mom and pop, that's pretty easy. If either mom or dad show up at a meeting to vote, that's pretty easy. But what if you have, as we all do obviously, have companies that have 40 or 50 employees, and the question is who gets to vote and how are the... So I gave you some language in here that, and I have a couple of places where I've given you some sample language, and if you, all you have to do is shoot me an email, and which I didn't put on here, I apologize. I'll be happy to email it to you. So the same sample language I have talks about the fact that you can have membership classes, etc. And you'll notice I put in bold any person And then I define what a person is. That way, throughout your bylaws, you can use the term person, and you don't have to say mom or dad or the entity or. So a person is any business, entity, partnership, corporation, sole proprietor, limited liability company, individual, or association. All right. And then I go on to say a member, which is an entity, may designate a natural person who is at least 18 years of age to vote or otherwise represented by the member in chamber matters. The board may adopt policies regulating this designation and what documentation or notice, if any, may be required to exercise voting privileges at chamber meetings or events. An entity member may, at any time, and at its sole discretion, change its entity designee. Every person who attends a chamber meeting or event and represents that he or she is the entity designee is presumed to have been properly appointed by that entity member, and the chamber has no duty to investigate or confirm that person's proper appointment qualifications or credentials. You can do this any way you want to. I wrote it this way because I didn't want to burden our staff with all kinds of IDs and are you the person you say you are and how do we know you and all that. My approach to this is if you show up and you say I represent XYZ company, we're going to accept that. All right? And the burden is on the member to make certain that that is the right person, etc. But we as a chamber are not, every time we have a member meeting, we're just not going to ask for photo ID and all that. Of course, you can do as much of that as you wish. Memberships are not transferable. That's by statute. Okay? Memberships cannot be transferred. I'm sorry, unless it's it's the opposite. Unless it's prohibited in your bylaws, memberships are transferable.
Meaning if the employee switches jobs, or what do you mean by?
Here's what I mean. Can XYZ company transfer its membership to ABC company? And the answer is yes, unless your bylaws prohibit that. And ours do. Ours say your membership in our chamber is not transferable. Okay. Meetings. I put some things in here that I thought when I went through to revise our bylaws, there are some things in the statute, and I put a few of those in here, which really surprised me and which I actually had just really forgotten. So, first of all, you're required by law to have an annual members meeting. Okay, you probably all do that anyway. And the time and date and all that is fixed in your bylaws. Remember, the topic here is bylaws. And then I have here, a corporation with members may hold regular meetings. I'm going to come back to regular meetings in a second. At the annual meeting, I put this in bold, the president and the chief financial officer shall, that's mandatory, report on the activities and financial condition of the corporation. Wow. That was one of those things, I didn't know that. I guess Scott gives us a report. I never really thought much about it, but that's mandatory by law. By the way, there's a difference in my mind between a gathering and a meeting, and a sort of official meeting. I mean, all the members might get together for lunch. Whether you deem that a meeting or not, probably not. Okay? And I'll explain a little bit what I mean by that in a second. Okay. I have two in here. I'll come back to that. Regular meetings. So let's understand there are three kinds of meetings. There's an annual meeting, there's a regular meeting, and there's a special meeting. Okay? So the annual meeting is pretty self-explanatory. We're going to talk a little more about that as we go along. But an annual meeting is, okay, we meet every year. There's only one annual meeting, or just one of those, and that's pretty easy. Regular meetings are meetings that you schedule and you say, let's use it in the context of the board of directors. We, the board of directors, are going to pass a resolution, or you may have it in your bylaws. We're going to meet the second Monday of every calendar month. That's a regular meeting. You don't have to send out notice of that meeting because you've made a decision that you're going to meet at a regular time and day for that year or whatever. So for regular meetings, regular just means repetitive and that you've established it and you've either set a particular day of the month or you've set some means by which everyone can determine when that meeting is going to be, whether it's quarterly, whatever that might be. All right? A special meeting is everything that's not an annual meeting and not a regular meeting. All right? A special meeting is, I think we need to have a meeting because we have some issues we need to deal with. When you have a special meeting, there are notice requirements, and across the board, LLCs, corporations, nonprofits, all that, the rule always is that you must describe the agenda for that meeting. All right? So let's back up. Let's do this in the member context. I would think it would be very rare for you to have a special members meeting. I'm not sure why you would have one. You might have some really significant event that requires you to give every member in the chamber notice, and you're going to have this meeting, and you have to tell them what's on the agenda, and so on and so forth. I would suspect that's not very often, but we are going to talk about special meetings in a second. I'm going to guess that you probably don't have regular meetings. You might. Maybe some of you really have a true regular meeting. If you do have a regular meeting, it has to be established in your bylaws. Okay? The board has no authority to set regular membership meetings. I didn't make the law, just telling you what it is. You're not required, okay, so you're required to have an annual meeting for members. We're at the member level now. You're not required to have any other member meeting, just one every year. That's mandatory. That's required by law. You're not required to have any other member meetings. You don't have to have quarterlies, and you don't have to have special meetings. You don't have to do anything other than show that you had your annual meeting. If for some reason you would want to have regular meetings, that has to be in your bylaws. All right? Which, by the way, is a real pain in the rear because amending bylaws is not an easy task. All right? But should you want to have regular meetings, the real takeaway here is the board cannot just decide, I think we're going to have regular member meetings every quarter. Can't do that. Got to go in the bylaws. All right. No fun, huh? Special meetings. Who can call a special meeting? All right, so when you see, if I put the word default in here, what that means is if you don't take any action, if you don't describe something in your bylaws, then the statute is the default, and it tells you what you do if you haven't written it out for yourself. So the default in the bylaws for special meetings is that the board, not a board member, the board may call a special member meeting, and anyone that you say in the bylaws can call a special meeting, at the risk of sort of stating the obvious. Right? So I think in our bylaws we have some provision that 10% of the members can call a special meeting or something like that. You probably all have something similar to that. And your agenda at that members meeting is limited to whatever you put in the meeting notice. All right? I know I'm bouncing a little bit for you here. For annual and regular meetings, you're not required, with a couple of exceptions which I'll come to, but as a general rule for annual meetings and regular meetings, you don't have to tell people what's on the agenda. They get whatever is on the agenda when they walk in the door. That doesn't mean you can't tell them in advance, but you're not required to. Okay? And the thought behind that is when you have an annual meeting, people may get up and they may have lots of things they want to talk about, and there's no way for you to know that in advance. And secondly, you don't want to bar them from raising issues because they didn't come to the office and say, by the way, I want to put that on the agenda, and you say, oh, no, we had to do that 30 days in advance or some stupid thing like that. All right. So the point is that annual and regular meetings, you are not required to include your agenda in the meeting notice. You can just say, we're going to have a meeting, or we're having our annual meeting. All right? Again, doesn't mean that you can't tell people what you expect to talk about or the things that you have on your agenda. But the meeting is generally wide open in terms of whatever issues you want to bring up. You know, as a best practice, I don't think it's a good idea to surprise your members with issues. So if you know they're going to come up, I think, you know, why not tell people and let them know what's on the way. All right, so let's talk about meeting notice. Actually, I think I cover that in. I thought I did that in more detail. All right, meeting notice. So, the question is, how? Let's see if I got this. Yeah, I do. All right. How and by what process are you allowed to give people notice of the meeting? All right. Got to do a little history here. This statute was adopted in 1995. All right, let's see. 2005. Okay, that's. I don't remember. We didn't have a lot of email back in 1995. As I recall, I was a young lawyer, and as I recall, we had internal email, but I'm not sure we had external email. If we did, certainly it was not as it is today, where everybody has at least one email address, right? So you got to remember that this statute was adopted in 95, and just how forward-looking they were, I don't know. But, so let me walk you through this. The statute says you can give notice by any means that is fair and reasonable. Okay, great. So that gives you a pretty wide open door to decide how you want to give notice. Then it says, we're going to give you a safe harbor here. Do you know what I mean by the term safe harbor? That's kind of a legal term that lawyers use, or a statute will sometimes say, you have to get to first base, all right, by any fair and reasonable means. If you want to know what's absolutely safe so your client doesn't get sued, here's the safe harbor. You have to walk to first base. Okay, all right. So the safe harbor here is, if the corporation notifies its members of the place, notifies its members time of each annual, regular, special meeting, no fewer than 10. So safe harbor is not less than 10. Or if notice is mailed by other than first-class mail, then you have to give at least 30 days notice. Now notice this says if notice is mailed by other than first class. So it doesn't talk about email, talk about faxes or any of those things. So my view of this is, and I'm going to show you our sample language here in a second, that email is certainly fair and reasonable. And I guess if we were going to be concerned about documenting that you gave people notice, you're going to have, of course, email addresses for all your members. I guess you already have all that. That's kind of a silly thing to say, really. But, okay. Annual regular meetings. Notice need not include any agenda or terms to be voted upon. Notice I said already that annual and regular meetings, you are not required to give them anything that you intend to talk about. These are the exceptions from the statute. So if any of these exceptions come up, you must include this in your meeting notice that you will discuss these items. Those are the exception to the rule. Most of them are pretty heavy stuff. Amending your articles, merging the chamber, selling property out of the ordinary course of business. These are really big, significant items. And I can't imagine that you wouldn't put it in the notice anyway, but just a heads up. I keep repeating myself here. Special meetings has to include the description of the matter. I think we talked about that.
So on here it says that we have to inform our members if they need to approve an amendment to a bylaw.
Correct.
Do they have to approve every amendment to a bylaw, or can that just be voted on by the board?
I'm going to come to that.
Okay.
The answer is the board of directors cannot amend your bylaws. Okay? That's going to come as a surprise to some of you. And let me tell you why that's going to come as a surprise. Because the state statute before 1995 was wide open. I mean, the nonprofit statute in Missouri was like 3 pages. Okay? I mean, it was hardly anything in there. It was like, kind of do whatever you want. All right? With certain exceptions. And so a lot of chambers just simply said, well, if we need to amend the bylaws, and they had in their bylaws that the board could amend bylaws. When I went back to do our chamber bylaws, that's what we had. And I went, whoa, how come I haven't paid attention to this? All right? We haven't had any bylaw amendments in so long that I guess no one ever really paid much attention to it. All right? But so heads up, and I'm going to come to that. I will come to that here. Heads up that the state statute does not allow your board of directors the authority to amend your bylaws. Okay? All right. I don't know what the statute of limitations on that is, but just you be aware. Okay. Exception. The notice must include a matter a member intends to raise at the meeting if requested in writing to do so by a person entitled to call a special meeting, and the request is received by the Secretary or President of the corporation at least 10 days before the corporation gives notice of the meeting. This is why you really want to get your volunteer attorney to do this, because this will make your brain hurt really bad. Okay? Let the lawyers figure out all this crazy wording. So here's what this says. It says that you have to include in the meeting notice anything that some member comes and tells you that they want on the agenda. But it has to be a person who's entitled to call a special meeting. Okay, so here's what that means. Let's go back. Earlier in the outline here, remember we said who has the right to call a member meeting? A, the board of directors, always. B, anyone you put in your bylaws. If you say Fred has the right to call a members meeting, that's who they're referring to. So it's not any member. It's only a person or persons who have the right to call a meeting. That person or that group of people can come to the chamber office and say, for this next member meeting, I want this item on the agenda. So it's not just any member. It's only people who have the right to call a meeting. All right? Keep in mind, this is not about who has the right to raise an issue at the meeting. This is about what has to go in your notice. So we're still talking about notices here. So don't get confused. All right. Here is the sample language that I wrote when I amended our bylaws not so long ago. And to the extent that you like this, some or all of it, let me know, and I will happily email it to you. Some of this I took out of the language that I use on the corporate side, and I adjusted it for nonprofits. You'll notice that I have a provision in here on email. If you like it, great. If you don't, well, at least it gives you some food for thought. Okay, more fun stuff. Quorum. The default is 10%. So if you don't have anything in your bylaws about quorum for member meetings, if your bylaws are silent, it's 10%. Okay? You can have, obviously, you can change that in your bylaws. You can't make it less than 10%. But so let's walk through this. Unless this chapter or the articles or bylaws provide for a higher or lower quorum, 10%. Well, actually, I guess you could provide for lower. It's 10%. 2, a bylaw amendment to decrease the quorum. So if you're at 40 and you want to change it to 30, must be approved by the members, or unless prohibited by the bylaws by the board. So there's an exception for you. Quorum requirements apparently may be approved by the board unless it's prohibited in your bylaws. This stuff it really makes your brain hurt because most statutes, and I know, thank goodness, you all don't sit around reading statutes like we do, but most statutes will say, here's the rule unless you change it in your documents. Some of the stuff in the statute reverses that out. It says, and this is one of those, unless prohibited in the bylaws, the board can do this. I teach limited liability companies for the Bar Association to lawyers. And one of the things that I try to teach to them is, as I recall, there are something like 48 defaults in the LLC statute. And the key is to understand what those defaults are, because if you don't put it in the operating agreement, your client is going to have to operate based on whatever that statutory default is. Most of what's in your nonprofit statute says, unless the bylaws say this, here's the default. And I would say a vast majority of the time, the statute gives you the power to change what's in that statute if you put it in your bylaws. But you have to put it in your bylaws. Otherwise, of course, you take the default. Does that make any sense? Okay. A bylaw amendment to increase the quorum has to be approved by the members. I find that kind of interesting. You would think it would be the reverse. To lower it is easy. To increase it is more difficult. So, all right. Unless 1/3 or more of the voting power is present in person or by proxy, the only matters that may be voted upon at an annual or regular meeting are those matters that are described in the meeting notice. So one more exception to the meeting notice rule. So if you don't put in the notice that you're going to talk about the color of your sign, if you don't put that in the notice, and you have less than 1/3 of your membership there, you can't make a decision on the color of your sign. Did everybody follow me on it? Let me say that again. If it's not in your meeting notice, not on your agenda, that you have given out in advance, it's not in there, and you raise something at the meeting that's not in your notice, you can't adopt that if you have fewer than 1/3 of your members there. Now, technically this says voting power. Now, I don't want to get deep in the weeds on you here. Theoretically, members and voting power can be different. But as a rule, voting power really just means, do you have 1/3 of your members there? Do you have 1/3 of the votes there? Okay. I put in here a contrast that we're talking about quorum here, and I know it's easy to get confused. So far, what we're talking about here is quorum. Notice that when we come to voting requirements, that has to be approved by the members. All right. Proxies, don't do it, is my advice. All right. So the default in the statute, let's read it. Unless the articles or bylaws prohibit or limit proxy voting, a member may appoint a proxy. Personally, I think that's a nightmare. All right. I think in our bylaws we prohibit the use of proxies. All right. You know, whatever floats your boat here, but I didn't print the statute out for you here, but if you read the statute on what you have to do to document and manage proxies at your meeting is really nuts. I mean, you're going to have a headache and a half trying to work through proxies. As a practical matter, I guess no one really will know or care. You know, I mean, now, keep in mind that the language I gave you early on about entities says that anybody who shows up and says, I work for, or I'm an owner, or I somehow represent this ABC Inc., you're entitled to accept that based at least on that language that I wrote. So in some measure, you don't need proxies if you adopt something similar to that. But my suggestion to you is, in your bylaws, I would prohibit proxies. Okay. How many votes do you need? Okay. Well, the default is a majority of your quorum. Okay. So again, you have to know what your quorum requirements are, and the default in the statute. So if your bylaws don't say anything, doesn't say anything about how many votes it takes to approve something, the default is a majority of a quorum. Only members, by amending the bylaws, can increase or decrease that number. You may have things that you feel are important to be approved by 2/3 or 3/4 of the members. Maybe selling property, you want to say, I want 2/3 of the people to approve this. Whatever, you can do that. All right, record date. How many of you have? I got 5 minutes. Is that all? Okay, well we'll get there. We'll get there. We're
Just
close.
giving you an update.
Thank you. We're
Yes,
close.
sir.
We're really close. Okay. How many of you have ever heard the term record date? Yeah, I'd be amazed if any of you had ever heard of record date. Record date is something that is used in the for-profit world, but has been put into your nonprofit statute. The record date is you choose a date, and you say anybody who's a member as of September 1st will have the right to vote at this upcoming meeting. I can tell you, we don't pay any attention to that. And I'm guessing none of you have either. You either don't even know what it is, or haven't paid any attention to it, or don't care, or all of the above. But I want you to understand what a record date is. And it says in the statute, the board may set a record date. So, the board may say, for this upcoming annual meeting, we're going to set a record date, and that record date will be X, and anybody who comes in as a member after that date will not have the right to vote at the annual meeting. You are entitled to do that. Again, what's the default? If the board does not set a record date, the default is those who are members at close of business on the business day preceding the date of the meeting notice. Isn't this fun stuff? And you're like, what does that mean? Okay, so Let's read it again. Those who are members at close of business on the business day preceding the date of the meeting notice. So let's say that your bylaws require 10 days notice for your annual meeting. Anybody who's a member the day before that 10 days notice is eligible to vote. Does anyone care? Probably not, but I want you to know what the rules are. See list of members below. I'll get to that in a second. Action by written ballot. If you like nightmares, do this. And that's what I really. I didn't give you a copy of the statute. You can look it up. I didn't give you the number. But if you really want to lie awake at night, put something in your bylaws about written ballots. It is, it's crazy. It would take an immense amount of time, effort, and headache to approve anything by written ballot for your members. It's your chamber. You can do what you wish, but I would prohibit written ballots in your bylaws. I would say we don't approve things by written ballot. Okay? It is permitted unless, again, you say in your bylaws we don't do written ballots. All right. Action by consent. Those of you who have any background in small business or corporate and whatever, you will know that out in the corporate world, if the shareholders or the directors are going to make a decision, they can either have a meeting, in which case they need to send out notice and go and jump through all these hoops, or if you have a small business, they only have 3 owners, they can adopt anything they wish by unanimous written consent, meaning we put our decision on a piece of paper and we all sign it. We don't have to have a meeting if we do it by unanimous consent. In the case of nonprofits, 80% is sufficient to accomplish anything by written consent. What is that? And there's no notice required. You don't have to send your members a notice and say, by the way, we're circulating this written document for signature. You could actually put something on a piece of paper that says, we resolve to do this, this, and this, and if you got 80% of your members to sign it, you don't need a meeting to accomplish it. Everybody follow me on that? Not sure that you would want to do that. In our case, trying to track down 80% of our membership for a signature would be, I would think, next to impossible. Notice this is not 80% of quorum, this is 80% of your membership. Okay. Seal. I just threw seal in here because seals are like centuries old. If you have anything in your bylaws which says we shall have a seal, that's okay. You're not required to use it anymore. I have a provision which I put in our bylaws which says we don't have to have a seal. We can have one if we want it, but if we have one, we don't need to use it, blah, blah. Okay. Last and then out, I promise that this is it. Okay. Bylaws may be amended by these methods. By 2/3 of the votes actually cast at the meeting. Okay, so A, you have to have a quorum, and B, you have to have 2/3 of the votes actually cast at the meeting. You're more than likely to have more than a quorum, so it's 2/3 of the actual votes cast, or a majority of the voting power, whichever is less. Now, voting power is not your quorum. Okay? All right. If the board of directors initiate the proposed amendment, the board may set a higher voting requirement. So the board of directors can propose a bylaw amendment, and if they do, in their proposed amendment, they can say, in order for this to pass, we're setting a higher limit than the 2/3 or majority, whichever is less. And my last thing for you, which if you're sleep deprived is really great stuff. I ran across this in the statute and never really paid any attention to it, but I suggest you read it because it talks about the requirements that you have for maintaining membership records. And this is mandatory stuff. So you have to read it. And I suggest in this case, don't have your lawyer explain it. Just sit down and read it. Because you really are supposed to do all the things that are in here in terms of keeping lists of members and so on, so on, so on, so forth. Okay? All right.